Your Excellencies, Heads of Diplomatic Missions, Justice Twea, Justice of Appeal, and senior members of the Judiciary, Solicitor General, Honourable Members of Parliament, senior government officials, distinguished guests, and members of the press, Mwalandilidwa, welcome. Please excuse my pronunciation. My name is Edward Paice. I'm Director of the Africa Research Institute in London, and I would like to welcome you all to this, the launch of Duty of Care, Constitutional and Law Reform in Malawi by Janet Chikaya-Banda, who is Chief Law Reform Officer at the Malawi Law Commission. I'd like to extend very special thanks and welcome to Justice Edward Twea, who has very kindly come to speak this evening, and also to Anthony Kamanga, the Solicitor General, who has very kindly agreed to step in and speak on behalf of, or maybe not on behalf of, but instead of the Attorney General. My thanks, of course, also to Janet Chikaya-Banda, with whom it has been a great pleasure and a privilege to work over the last 8 to 10 months. If I may, before I return to the speakers and the format for the evening, just say a few words about Africa Research Institute. We are a small think tank based in London, wholly independent, non-partisan, and we were founded 5 years ago in 2007. We have a very simple mission, which is to look for ideas and initiatives with a record of success in sub-Saharan Africa, and to suggest new ideas and initiatives where they may be needed. In doing this, we always work with practitioners, either with groups or with individuals who are doing the work in Africa, and we then seek to disseminate what they have said and their experiences right across the continent as well as in Europe. It's particularly crucial to us that we make the information relevant to practitioners elsewhere on the continent who are in a similar position. So, for example, tonight, what is this publication, we hope will be particularly instructive for law reformers throughout sub-Saharan Africa. We generally look for themes and have worked for that reason on agricultural topics, on urban topics, on health topics, and also on many topics to do with political institutions of one sort or another, and institutions involved in constitutional reform. We are not country specific, but it has been a great pleasure for us to write 3 times in 5 years about Malawi. The first publication, which was co-authored with Blessing Chinsinga, was about the fertilizer subsidy program. The second publication was a study of Nkani Zamaboma, News from Districts, the radio program. And now we have this, the third publication. If I can come back to the speakers, and I will deal with them in the order in which they'll speak, if that's all right. Janet Chikaya-Banda has been Chief Law Reform Officer at the Law Commission since 2002. The Law Commission, in case any of you are unfamiliar with its work, is the independent permanent body mandated by the Constitution to undertake the review of all domestic laws, including the Constitution. In her capacity as Chief Law Reform Officer, Janet is responsible for all law reform programmes and for managing the Commission's Legal Affairs Division. She oversaw the Constitutional Review Programme undertaken by the Law Commission in 2004 to 2006, including the nationwide consultation that formed part of that review. And it is she who compiled the report that emanated from that review and was presented to the first National Constitutional Conference. Curiously enough, that first National Constitutional Conference and the second one, which followed it, took place in this very room. So I think it's appropriate that our minds are focused on the whole issue of constitutional reform this evening. Justice Edward Twea, trained as a criminal lawyer, very distinguished member of the Judiciary, and has kindly agreed to give the perspective on law reform from a leading member of the Judiciary. Furthermore, one who has sat on a number of the special law commissions, the body of experts that the Law Commission appoints when it's undertaking individual review programs. He's, as I say, sat on many of the commissions, particularly during the process of reviewing the criminal justice system, which after the 1990s and the introduction of multi-party democracy was in particular need of overhaul, and that is an ongoing programme being undertaken by the Law Commission. The Attorney General I've only just met, and I'm quite sure that most of you in the room know him better than me. I will just thank him again very much for stepping in to give a response on the part of the government to the presentations by Janet Chikaya-Banda and Justice Twea. The format is that everyone will speak for about 10 or 15 minutes. After that, because things are running quite late, not least due to the unfortunate problem with the power, if I could ask you to approach the speakers individually with questions and points, I think that's much easier than if we have a prolonged question and answer session. I would just like to welcome you all again, and do please keep in touch with Africa Research Institute if you're interested in the topics that we cover and seek to draw attention to. Do please leave a business card on the desk on the way out if you wish. And while everyone is speaking, do please enjoy the food as well and the drink. And I'd like to express my particular gratitude to you all for being here, given the problems with the power and the rain, and it's not been easy. Thank you very much indeed. I'd like to welcome Janet Chikaya-Banda, Chief Law Reform Officer at the Malawi Law Commission.
Good evening. Distinguished participants, all protocols observed. I'm humbled to stand before such a distinguished audience and share my personal experiences. Edward has asked me to talk for 10 minutes. I cannot promise, because we cannot talk about constitutional reform in Malawi within 10 minutes. It's not possible. We've been doing this for the past, I think, over 10 years. But I'll try my best. I do not take it for granted that you have come here to listen to this presentation. I know constitutional reform is a very emotive, I think, topic in Malawi at the moment because of particular provisions in the constitution that may be causing discomfort. I've worked for the Law Commission for the past, I think, 14 years. And I remember that what attracted me to that institution at that time was the rumor that there was a constitutional review in the offing. That time I was serving as a principal state advocate in the Ministry of Justice. And I rushed. I had just completed a master's degree in constitutional law, and I couldn't wait to apply my knowledge. When I joined the Law Commission, I was disappointed in 1998 when I was told that the institution was too young. It could not carry out such a huge exercise. But nevertheless, at that time, the Law Commissioner, who was Justice Singini, said that we would attempt a technical review of the Constitution. So I was a bit comforted because I was still in the place where people were looking at the Constitution. The Law Commission at that time only had a handful of officers, no legal officers. We didn't have knowledge of how to implement law reform. It was a new area of practice of law in Malawi. So we were just fishing out. we settled for a technical review focusing on correcting grammatical errors in the Constitution, looking at inconsistencies and punctuation, just to make sure that the document was edible, readable, without really going to the substance of the document. So it was in that sense that I joined the Law Commission. Since that time, the Law Commission has grown. It boasts of a staff complement of about 60 members of staff. It's a very robust institution, and it has carried on a lot of law reform programs. The gist of the publication that has been distributed is really just to emphasize the importance of law reform, especially systematic law reform for a young democracy like Malawi. I also want to highlight the challenges and opportunities that are there for law reform. And more importantly, I want to lobby. I want to lobby government to take time and fish out that report, the report on the review of the Constitution, and move forward the recommendations that were made in that report, mainly because it incorporates the views of a lot of Malawians because of the nationwide consultations that were involved in the reform. So I think the way I will approach the discussion is that I'll give a brief, overview of our Constitution, mainly just to underscore the duty of care imposed on those who are charged with the responsibility of exercising state authority. And then I'll try to show how that duty of care maps into the responsibilities and mandates of the three arms of government. Really, why I'm doing that is that I want to expose the institutional challenges and also the structural challenges within which the Law Commission of Malawi operates. At the same time, highlighting the opportunities that are there for the institution and also for government to utilize. Then I will briefly talk about the constitutional review exercise, only focusing on the time that was spent on that exercise, the cost, and also the effort, especially from the part of the Law Commission itself as an institution, simply to highlight the implication of ignoring the recommendations that are contained in that report. Then I'll just talk also in passing about the other challenges that are facing the Law Commission as an institution in implementing its mandate. The title of the document, Duty of Care, is very befitting. It's a concept that is usually employed in tort law, emphasizing the standard of care that should be exercised by individuals in society not to harm others. In constitutional law, I've interpreted it to mean a standard of care imposed on those exercising state authority, demanding that they adhere to a certain level of principles, to constitutional principles, while exercising state power. And I always go to chapter 3 of the Constitution, because it's my favorite chapter in the sense that it gives you the fundamental principles upon which the Constitution is founded. It also sets the standard against which implementation of all the provisions in the Constitution should be measured. That chapter is divided into 3 categories. We have what are called constitutional principles, and then we also have what are called principles of national policy. I focus only on the constitutional principles because they're the ones that are relevant, especially for law reform in Malawi. And I summarize them as follows. 1, state power comes from the people and is to be exercised by the people. Is to be exercised and applied solely for the people, in their interests and to protect them as well. State power, the exercise of state power is on people's trust and in trust for them and should be exercised to the extent of such authority. Exercise of state power is conditioned upon the sustained trust of the people maintained through an open, accountable, and transparent government. Exercise of state power must recognize and respect dignity and worth of every human being and protect fundamental individual human rights. We can all see that already these principles are tilting towards good governance in Malawi. The last two are to do with the observance of the rule of law. All people have equal status before the law. No person or institution is above the law. There are two significant characteristics coming from these principles. One, they bring out the democratic nature of our constitution and spells out the standard of governance required for those exercising state authority. They also place people at the center as beneficiaries of state power and demands observance of the rule of law. People may ask why I'm highlighting this. The question that I want to pose this evening, or the question that I want people to think about while I'm discussing the issues in my publication, is how these principles map into the responsibilities of the three arms of government as agents of law reform. I'm looking at them specifically as agents of law reform. For example, if I start with the executive, we all know that the executive's responsibility under Chapter 1 of our Constitution is to initiate policies and legislation and implement laws. That is the responsibility that has been given to the executive arm of government. But what is the duty of care that has been imposed on the executive? The Constitution requires that the executive, in implementing or initiating policies and legislation, they should ensure that those policies and legislation should embody the express wishes of the people of Malawi. So that's the duty of care that has been imposed on the executive. And one way which I feel that the executive could fulfill this duty is by utilizing the institution of the Law Commission. It is conveniently located within the executive arm of government, and its mandate is very broad. It has been tasked to review the Constitution. It has been tasked to review all laws in Malawi, to harmonize the laws, to codify customary law, and most importantly, to receive submissions from anybody in society. And in that way, it allows non-traditional actors to initiate legislative reforms in Malawi. How else do you embody the express wishes of the people of Malawi? You're telling the people that you can go to this institution and ask the government to look at this law if it's not working properly. And it's not only the mandate of the commission which is advantageous. Its establishment, constitutional status places it high. It's a constitutional body. Everybody notices it. Independence. It is guaranteed independence from interference in the performance of their duties. This adds to its credibility in terms of the work that comes, or the legislative proposals that come out of the institution. The methodology itself is also advantageous, which government can utilize. It works through special law commissions comprising of people who are lawyers and non-lawyers. This is very peculiar to Malawi. I've gone to several law commissions in the region and even beyond. Normally, it's only lawyers who are working in law commissions, who are working in law commissions. But the idea of involving non-lawyers is good in that it promotes a multidisciplinary approach to law reform. It's no longer legalistic. So you're looking at social issues as well. By addressing social issues, looking at social issues, you're already taking into account the views of the people, what they want their government to do. On top of that, in Malawi, because of the shortage of experts, because the Constitution requires that we work with experts, we work with stakeholders. And stakeholders are even better than experts in the sense that they are practitioners on the ground, and they provide useful insights into the operations of whatever law you're looking at. And in addition to that, the law reform process itself, it is highly consultative. We convene meetings to ask views of the people, workshops, we use the radio, whatever media forum is there, we use it. all in a bid to ensure that the law reform process is participatory. So in that sense, it also promotes a very participatory approach to legislative reforms. The government should embrace this. What are the other bonuses for using the institution of the Law Commission in terms of government? It can help government achieve a balanced legislative agenda. I'm saying this because I've noticed that in the past few years, government has focused on money bills, introducing money bills in Parliament, either to promote revenue collection or to facilitate access to bilateral or multilateral loans. I was looking at 2011 as a year and just looking at the bills that have been enacted into law in by Parliament. In 2011, 24 bills were introduced and passed in Parliament, and out of these, 16 were money bills. Are there no other social issues that need to be addressed in Malawi? In 2010, the same pattern. So it's really a plea to look at the Law Commission as an institution that can fill that gap to balance the legislative agenda of government. When I go to the legislature, we all know that the mandate of the legislature is to enact laws. The duty of care that the Constitution places on the legislature is that when they are deliberating bills or the business in Parliament, their deliberations should reflect the interests of the people of Malawi. But there's also an additional responsibility that has been placed on the legislature. It is an organ that has been tasked to create a constitutional order based on an open, democratic, and accountable government. So the question is this duty of care placed on the legislature being fulfilled in Malawi? I can talk about self-serving amendments done to the Constitution in 1995, the recall provision, the repeal of the recall provision, the repeal of the Senate provisions. The bottom line, those amendments removed accountability of the House to the people. It's common knowledge. There are also self-serving practices in the House. People are now talking, everybody, it's in the newspapers, everybody is talking about the way Section 65 has been treated with impunity in the House. Then an implementation of Section 65 cripples the effective functioning of Parliament. And I could even move on to the issue of private members' bills. Members of Parliament are empowered, or they can initiate private members' bills. This is the whole idea why Law Commission reports, when they come out, they go to the minister and they are given to Parliament, so that maybe they can pick out other issues that they can take up as members of Parliament. But what has happened? The reports are just piled in the library in Parliament. They are not even distributed to members of Parliament, despite the cost of printing those reports. I also checked that since 1994, only 4 private members' bills have been initiated in Parliament, and none of these saw the light of day. And also, more importantly, and disappointingly, most of them were politically motivated. I could cite 1 or 2. The bill to amend to extend presidential term of office. There was another one to amend the Reserve Bank of Malawi. I think not to allow the use of faces on paper money, sorry. So all this, at the end of the day, cripples the proper functioning of the institution of Parliament, and also, I think, contributes to its failure to adequately fulfill the duty of care imposed by the Constitution. The Judiciary has been tasked with the mandate of interpreting, protecting, and enforcing the Constitution and all laws in Malawi. The duty of care that has been placed on the Judiciary is that it should exercise this power in an independent and impartial manner. And also, it has been tasked to ensure that the Constitution is the final arbiter of all disputes in Malawi. In that sense, in deciding cases, the judiciary engages in the development of the law. That's, I think, a form of law reform because they try to adapt it to changing circumstances. But what are the limitations of the judiciary? The limitations of the judiciary mainly is to do with the way that they decide cases. It's very piecemeal, since their primary function is to adjudicate cases, to decide cases. Judicial reform can only be systematic over a long period of time. It's different when it is done by an institutionalized institution like the Law Commission. And also, when you talk of appeals, the process itself is expensive, not readily available to the common person. So, my conclusion about the judicial as an agent of law reform is that most of the questions in the law may remain permanently unresolved because of the way it operates, the way the judiciary is structured to operate. So all this to emphasize the importance of law reform through the institution of the Law Commission. But there are positive practices from the judiciary that have developed, I think, over the years. The Law Commission, since its establishment, it has worked with over 20 judges in various law reform programs, which is a plus for us in the sense that it helps, and this is not from my head, this is from the interviews that I had with a few judges. It helps judges understand and appreciate policy and legislative history behind laws under review. And also, the involvement of judges, this I gleaned from a number of, decisions that I've seen. The involvement of judges subconsciously influences their decisions when adjudicating matters involving laws. Whatever they learned through that process, and if a matter comes concerning that law, you can actually easily see it in the ruling. This is a bone of contention for others. They don't like it. But for us, I think as law reformers, we see it as a positive and consider that law reform in Malawi is forward-looking in the sense that we involve judges not only as experts, but also as we recognize their role as agents of law reform when deciding cases. Now I move to the constitutional review. Everybody knows it's been in the papers about, I think, some provisions, but I can say that this is one of the major and successful programs that the Law Commission has carried to date. The review took 3 years. It was from 2004 to 2007. A lot of work went into that work. Consultations, logistics, anything you can think of. So there was a lot of effort. I'm emphasizing that so that people can just imagine the cost in effort that went into that exercise. And then we talk about the monetary aspect. I think it was around 55 million involved, if I'm not mistaken. And the finances came from both government and donors. So a lot of money was put into that work. And not only that, a lot of thorough and thoughtful research went into it as well. In the Law Commission at that time, all the lawyers became program officers on that. We actually put a stop to all the programs that we're learning, and we're focusing on that review exercise. I'm saying this to emphasize the cost in money, time, and effort that went into the report that is gathering dust somewhere in Capitol Hill. The report was completed, finalized, submitted to Cabinet through the minister at that time in 2007. We are still waiting for government to act, which takes me to the general challenges that we are meeting as a Law Commission, operating within the constitutional framework that we are operating under now. Adoption rate of Law Commission reports is very poor. The constitutional report had 8 bills, has 8 bills, draft bills in it. I'm aware that Parliament just passed a law on tripartite elections. Then I went back to the Constitution to look at the other amendments that were supposed to be done together with that one. The local government, the provisions in the Constitution dealing with Local Government Act. So we have that, but that one is still outstanding. We are failing to promote systematic law reform in Malawi. We have amendments that are overtaking other amendments that are supposed to go first. Since 1996, when the Law Commission became operational, the Law Commission reports that have come out have generated 53 draft bills. Out of those 53 draft bills, 37 are still pending before Cabinet or Parliament. That gives a 30% adoption rate, which is a cause for concern. Not only the issue of adoption rate, there's also the issue of inordinate delays in adopting or passing bills emanating from the reports of the Law Commission. I could give an example. The Penal Code took 11 years, the proposals that we made, the amendments, the proposed amendments that we made to the Penal Code, took 11 years to see the light of day. It was only passed in 2011. The work was done in 2000, and it was passed in 2011. The Criminal Procedure and Evidence Code took 7 years. I'm I think focusing on the criminal justice reforms because these are the ones that have, I think, these are the ones that have where we have had challenges. It was a comprehensive program, a lot of statutes, but a lot still waiting to go through. For us, this cripples the achievement of a systematic development of the law in Malawi. These are not the only challenges. I'll just cite the last one, funding levels for law reform programs. At the moment, government funds ORT and I think recurrent budget, if I'm not, current. We have carried out 23 programs. Out of those 23, government has funded, I could say 2.5, because the constitutional review was partly sponsored by government and partly sponsored by donors. So that gives you a figure of 20 programs sponsored by donors. What message are we trying to send? Do we have a political will for law reform in Malawi? Despite the challenges, I still feel that law reform is very important and urge and plead, especially that the Solicitor General is here, and I should recognize that I think the new administration has taken measures to move forward some of the bills that have been pending before Parliament, and we are very grateful at the Law Commission for this development. I still urge the Solicitor General to recognize that law reform in Malawi is very important because of the nature of the way it is done, the thorough research, the thoughtful research and analysis that goes into it. Its potential to promote systematic development of the law, if only government can also adopt an approach that is systematic to the adoption of law commission reports. It is also important because it promotes a participatory approach to legislative reforms. It's not only the preserve of the bureaucrats in Capitol Hill. The local man can walk into the law commission and say, can you please look at this statute? It provides a credible and trustworthy tool for legislative reforms in this era, especially where people are very suspicious of their governments. It fills the gaps created by internal and external limitations of the three organs of government. And in that way, I consider that it strives to safeguard constitutionalism in Malawi. And in my opinion, I think it is the only tool capable of resolving legal aspects of social problems. So with those observations, distinguished guests and participants, I want to say that we look up to the Honorable Minister of Justice, and this is a message through the Solicitor General. We look up to the Minister of Justice as the champion of legislative reforms in Malawi, And we want to emphasize and encourage that office to continue fishing out all those Law Commission reports that are gathering dust in Capitol Hill, because, and this is most important, the legislative reforms in those reports embody the express wishes of the people of Malawi. And in terms of the constitutional review, the considerable cost in time, effort, and money involved will have been wasted. And the views of all the Malawians who contributed to that process through the nationwide consultation would have been ignored if the report is still ignored or keeps gathering dust in Capitol Hill. So on that note, I want to thank you all distinguished participants for listening to my plea and hoping that I think the plea will gather or bear fruits. I thank you. So, 10 minutes.
Thank you very much. If I could welcome Supreme Court Judge Justice Edward Twea.
Good evening. I think Edward went through the protocol list. Allow me to acknowledge the presence of the excellencies and heads of mission. And let me address you as distinguished participants, ladies and gentlemen, and of course, members of the press. I will speak briefly on my experience in law reform. I'll start with the fact that when the 1994 Malawi Constitution came into effect, it ushered in a new constitutional order which is based on constitutional supremacy and a entrenched Bill of Rights. And coming from the background of a one-party state, parliamentary supremacy, and likely non-observance of human rights, it was foregone that our laws required review and amendment to make them conformable to the new constitution. To this end, the constitution provided for the establishment of the Law Commission with the mandate, among others, to review and make recommendations regarding any matter pertaining to the laws and the constitution. In 1995, there was a stakeholders conference. It was here at this hotel. And this conference appointed a task force to examine which of our laws in the justice system needed review on priority basis. And this culminated into the report on judicial and legal reform and the establishment of the core group on judicial and legal reform. The core group was composed of government stakeholders and the donor community. The core group was guided by the report on judicial and legal reform to ensure systematic reform of our criminal justice. The Law Commission was established in 1996, And the Special Law Commission on Criminal Justice was appointed 2 years later when staff for the commission was recruited. I had the privilege of serving as its vice chairperson under the leadership of Justice Leonard Unyoro, senior counsel, as he then was. And I do recall that the current Honorable Minister of Justice and Attorney General was a member representing the legal fraternity, and I think the Solicitor General too was a member representing, with the DPP then, Mr. Kamdonia Sulu, representing the ministry. This Special Law Commission reviewed the Penal Code, the Criminal Procedure and Evidence Code, and the Traditional Courts Act, among others. Further, it was also responsible for consultation and drafting the bills on bail guidelines and fines convention. The bail guidelines bill was passed into Bail Guidelines Act, and the Fines Convention Bill was later passed into the Fine Convention Act. And these two are now part of our laws. They were not there before, they are new, came in since the new constitution. This Special Law Commission was the face of the commission appointed by the Law Commission. Several others were appointed thereafter, not least the Special Law Commission that reviewed the Constitution. And I dare say that the commissions that were appointed after the first Special Law Commission benefited from the experience of the first Law Commission. I would be failing in my duty if I do not mention that the process of developing issue papers, conducting public awareness, participation and consultation has greatly improved since our commission. I can bear witness to this. The first statute that our commission reviewed was the Penal Code, and the last was the Traditional Courts Act. When we started our work on the Traditional Courts Act, by then I was the chairperson of the commission. The process of developing issues paper had been refined because it was wider and more conclusive. I think Dr. Chikaya-Banda had alluded to the way they get views from the public. And with more officers, the research was deeper and wider. When sitting on that commission, one got the satisfaction of having sufficient tools with which to tackle the reform. All this points to the advantage of having a permanent law commission. When the Constitution enjoins the law commission to make our laws conformable to the Constitution and international laws, what does this entail? I would compare or liken the Constitution to the sun. The sun influences our days and nights. It influences the weather, even our agriculture. In the same way, our legal, political, and social systems must therefore be influenced by the Constitution. This is a tall order, and it brings to the fore how we decide on the reforms, and this inevitably calls to mind the composition of the Special Law Commission or commissions that are appointed, and the public awareness and openness. I think Dr. Chikaya-Banda had referred to this, how we pick those that sit on the commission. The Judicial Service Commission is a critical player in the appointment of commissioners. It has the duty to critically examine the expertise of persons appointed, that they must bear relevance to the matter under review. It is not sufficient that one is an activist. I think it would be wrong for us to take people on the commission just because they are the most heard or the talk more than the rest on a particular matter. I don't think that is an indication of being an expert at all. And many times, the Law Commission, as was pointed out by Dr. Chikaya-Banda, has depended on judges. And as she said, this sometimes has raised some murmurs that judges should not be there or are not appropriate being used. This might be right. However, in my experience at the Commission, I have come to believe that judges or judicial officers are invaluable to the reform process. To begin with, judicial officers work with the law, however remote that law may be. They are therefore able to connect the interdependency of our laws. This is often lost to the public and the legislators. I would give 3 examples on this point. The first is the decision by Parliament to put the age of a child at 16 years in the Child Care Protection and Justice Act. When the repealed act, when reference to young persons had been repealed, this was contrary to Section 42G of the Constitution, which protects all persons under 18 years of age as a special group in the criminal justice system. So we have a discord 16 to 18. That's a lost group. Second is the failure to amend the minimum age of marriage in the Constitution from 15 to 16, as this conflicts with the amended Penal Code, which puts defilement at 16 years. So what happens is that the Constitution allows someone to get married at 15 years with the consent of the parents, but the penal law says if you have sexual contact with such a person, you're committing an offense. So we have that kind of discord. Lastly, and I'm sure the parliamentarians are here, I'll not look this way, I'll look at where's Honorable Jovialema, my classmate, so I'm sure you will not complain. If I look the other side, they might complain. The repeal of Section 46 of the Penal Code, which was on the minister banning publications, has created a vacuum. Nothing replaced that repeal. So in essence, citizens of this country can import and publish anything. And I'll use an absurd example, like if someone imported publication on how to make home bombs or how to kill human beings without a trace, we have no law against that. Who's going to stop it? Because we have removed that provision that gave the power to someone within the state machinery to look at this and then put a stop to it. So there is a lacuna there. These reforms, I would say, demonstrate a discord on the interdependency of our laws. These gaps may not be visible to ordinary citizens, but they are definitely visible to the law enforcers, the police, the state advocates, and of course, the judicial officers. Because the police, when something goes wrong, they have to engage in some legal gymnastics to cure the problem. So they have to find a way of charging someone using the most absurd provisions. If the reforms were done in a way that takes into account the interdependency, we would have such a situation. The Bill of Rights comes with many benefits, but it challenges the old order to which the public jealously clings. It challenges our cultures, our religions, which do not always favor universality of the human rights. This will remain a sticking point with public consultations. I know Dr. Chikaya-Banda talked about public consultations. But these are the challenges that come with public consultations. To this, I recall the challenges that our Law Commission had when looking at issues of termination of pregnancy and the same-sex relationships. There was, very few people we consulted wanted to do anything with termination of pregnancy or same-sex relationships. But the question remains, where do we go with law reform in the face of public resistance or public ignorance? I bear in mind here that the Special Law Commission on the review of laws on marriage and divorce, and this became the Marriage, Divorce and Family Relations Bill, has proposed to outlaw polygamy or bigamy, notwithstanding that the Constitution recognizes all forms of marriage, including marriage by repute or cohabitation. There will be an inconsistency if that comes up. Then we have to think, do we take out marriage, all forms of marriage from the Constitution? Do we take out marriage by repute or cohabitation from the Constitution? Because the law is coming up with such a debate. The thing that has to be noted is that the report of the Special Law Commission that reviewed the marriage laws shows that the public did not want or does not want polygamy removed. But the Commission felt that it should be removed because polygamy discriminates against women. So when or where should the Law Commission ignore public view? This is a matter that will vex Parliament in the wake of the debate on same-sex relationship that has come to the fore. We have the public which does not favor same-sex relationship, but there's a drive to look at the universality of the law. The Malawi Judiciary, and therefore judges, is, in my view, conservative, but with a small c, not a capital C. I believe judges bring special insight to the working of the law. And in some cases, massive doses of change may backfire in the society, but not in all cases. So judges have to look at how to handle the law and bring changes. I know Dr. Chikaya-Banda said it's piecemeal, but those are the things that the judges have to look at. What do we change and how do we change in order to conform with the Constitution? Judges cross-refer the laws, and thus they are at an advantage to gauge what changes should take place or how changes should take place. And we must also bear in mind that the appellate system is capable of defining and redefining the legal parameters of the law in terms of what happens in the society. I therefore strongly advocate for judicial participation in the work of the Law Commission. Last, and more importantly, the duty of care that is now under review amply demonstrates the difficulty faced by the legislature in legal reform in the face of conflicting and competing interests with the executive. The bias in favor of law reforms that have political flavor is a strong reminder of the influence that the executive has over the legislature. Members of Parliament have to contend with the executive, who in turn have to protect their party positions. In the face of all this, the Law Commission, as an independent institution, offers the best hope to being heard for the citizens of Malawi. I know I may be accused of making sweeping statements, But I also know that politicians, I'm looking again at Honorable Njovyalema, never mind their goodwill, never fight to lose. So they will always want to win. I thank you for listening to my experience in the Law Commission. Thank you very much.
Thank you very much indeed, Justice Twea. And could I now welcome Solicitor General Anthony Kamanga, please?
Good evening, Excellencies, heads of diplomatic missions, Justice Twea, Justice of Appeal. I've seen Justice Mwale around. I want to recognize the honorable members of Parliament who are here, also senior government officials. I want to recognize Mr. Edward Paice, the Director of the African Research Institute, our host tonight, and also members of the press. Can I start by conveying the sincere apologies of the Minister of Justice and Attorney General, who was scheduled to attend this function, but has been unable to do so because he's attending to some other important matter. So sincere apologies. I've been called in to make some response, or shall I say a few remarks, to the presentations that have been made by Justice Banda, Justice Janet Banda. I prefer to call her Janet for reasons that will become obvious soon. And also to the remarks that were made by Justice Twea regarding his own experience with the Law Commission. I find myself in a bit of an awkward situation because, to start with, I could not disagree in public with the views expressed by Justice Twea. I would also have difficulty to disagree with Janet, because Janet has actually taken advantage of the fact that she knows that she is my strongest witness. And that remark that she made about, the Solicitor General doing something was actually meant to silence me. But that notwithstanding, can I just try to respond very generally and hopefully in the process clarify some perhaps misunderstanding that there may be with respect to the law reform process in Malawi. Before I do that, let me make it clear, as I've been instructed to say, that the government remains committed to supporting and taking forward the work of the Law Commission. If you look at most of the substantive legislation that has been processed based on the recommendations of the Law Commission, most of those recommendations have been adopted by the government, speaking generally, because the government understands the process of law reform, We certainly appreciate the amount of work, time, and expense that has been put in the process, and as a result of that, the government has tended to take in good taste the recommendations of the Law Commission. If you look at the funding levels to the Law Commission, I think it is fair to say that there has been some general improvement in terms of the funding of the Law Commission. We have also, and we continue to support the Law Commission in terms of, making sure that we build capacity in terms of equipment to facilitate the work of the Law Commission. If I can now perhaps turn to some of the issues that have been referred to, I wish to tackle this under two heads. First, I want to talk about general law reform, the recommendations that have come through the Law Commission with respect to law reform generally, and then I want to spend a few minutes also talking about the report on the review of the Constitution, what has been done, where we are, what the challenges have been. I am grateful that Justice Twea gave some very good background of how the Law Commission started its work, and he also highlighted the priorities that were agreed, I'll say agreed, by the stakeholders back in 1995. The priority to look at reforming our justice, our criminal justice system. And I wish to agree with Justice Twea that a lot of work was done in that area. The report of the Law Commission on the review of the Penal Code, the report of the Law Commission on the review of the Criminal Procedure and Evidence Code, the bail guidelines, conversion of fines, that was agreed by all stakeholders at the time as a priority area. And most of our cooperating partners, including GFID, actually supported that program and those priorities. The challenge that we've had, though, in moving forward the recommendations of the Law Commission regarding laws in the criminal justice sector, I think we all know what the challenges were. Remember, we are talking early 2000, and then we had 2004, and I'm sure Honorable Jovialema will recall what challenges we had in Parliament. The delay in implementing the recommendations of the Law Commission were more to do with the challenges in Parliament rather than the commitment of the government to process, to push forward the reforms that have been recommended. Janet referred to the fact that the Penal Code amendments took, 10 years? Criminal Procedure and Evidence Code took 7 years. There is a reason for that. I think it's more to do with the challenges, the configuration in Parliament. But I think we have made general good progress because the government has adopted most of the reports of the Law Commission. The challenge has been to process the legislation. The outstanding bills, the outstanding reports, I can say, are being processed, and we are making good progress. Also, let us not forget what the scheme of things is. The reports of the Law Commission constitute or provide recommendations to the government and require the government, if the government agrees with the recommendations, to process, to initiate the legislation that is envisaged in the report. In cases where the government has a different view, the framework is that the government would refer back to the Law Commission whatever recommendation they have made, and ask the Law Commission to look at the matter again. I mentioned this aspect just to emphasize the point that although the government has always taken in good taste the recommendations of the Commission, there will be cases, there will be instances where the government has a different view on a particular issue. And in those cases, the recommendation or the report will be referred back to the Law Commission. There have not been that many of such cases, but I think there are one or two recommendations which have actually delayed the processing of the reports and/or recommendations of the Law Commission. Constitutional review. I will, Janet, I will take word by word your plea regarding the review, the report on the review of the Constitution. And the reason I'll do that is because I am myself equally concerned. I happen to be the Law Commissioner at the time that we were processing the review of the Constitution, and I personally know how much effort, how much money was spent. So I take the plea seriously. Nevertheless, the challenge that we've had with the report on the review of the Constitution should perhaps be obvious to most of you, at least some of you. You will recall that in the report on the review of the law, in the report on the review of the Constitution, which came out in 2007, there were quite a few contentious recommendations. I will mention a few. There was a recommendation to retain Section 65 And we know what the position, at least of government, was regarding Section 65. There was a recommendation to reinstate the recall provision. And we know what the position of the members of parliament were on the recall provision. And then there was also, wasn't there, the clarification of the term of the president. And there was a lot of debate on whether the president should appoint the vice president. I mention these issues because they were perhaps contentious issues. And one can perhaps understand why the process of considering the report on the law, the report of the Law Commission on the review of the Constitution, did not proceed as anticipated. That is history. I have been instructed to mention specifically that the government is revisiting the report of the Law Commission on the review of the Constitution, so that the government takes a position regarding the recommendations of the Law Commission. There are one or two issues that I also thought I could mention because they have been alluded to by Justice Twea. Law reform is a process, and in our case, the process does not only involve the Law Commission, the process does not end with the Law Commission. The law reform process at the Law Commission is perhaps the most elaborate that I know of. A colleague of mine mentioned to me the other time when we were talking about consultation in the context of the constitutional review, my colleague said, you Malawians consult too much. And do you really have the money to support the entire process? But our consultation does not end with the Law Commission. Our consultation and the consultation actually continues even in cases where government has adopted the report of the Law Commission and has processed the legislation. Section 46. Section 46 was probably, the government took a hit on 46. The government was accused of not having consulted. Civil society were up in arms. Our cooperating partners were not amused. And yet, we said that the review of the penal code, according to Justice Twea, Janet, we consulted. the point I'm trying to make is that law reform, even after the Law Commission have come up with their recommendation, should remain a process. The challenge is, where do you draw the line? When do you stop consulting? I think what I've said with respect to Section 46 is also true with respect to the New Police Act. There is a Section 35 there which has caused a lot of discomfort. And the point that is being made is that we have not consulted, or the government has not consulted. The issue of minority rights is another contentious issue, and I cannot put the challenge better than Justice Twea has done. We have, or the government has, in keeping in line with the scheme, the constitutional scheme for law reform, we have referred those issues back to the Law Commission for them to have another look. Because, as Janet said earlier on, the Constitution requires that the legislature, the government, should initiate policies and laws that reflect the wishes of the majority, or the wishes of the people. My point is that law reform will be a process, and it is a process. I think we can be proud. We've done fairly well. Out of the bills that Janet referred to in 2010, it may well be that the majority of bills were financial bills, but there's a reason for that. It's because we have a constitutional provision which says the government cannot contract a loan, the government cannot borrow unless the Parliament, expressly sanctions that borrowing to enable the government to move forward. I will be the first to admit that we have had challenges in the process, but overall, I think we've done well, and I wish to commend the Law Commission for the good work that they have done and continue to do, and you have the commitment of the government that we will continue to support the process. I think I've spoken more than 5 minutes. I've been assured that there are no questions that I need to answer, so I wish to thank you very much for your kind attention.
Thank you very much, Solicitor General. I always knew it was going to be something of a challenge, keeping everyone to 15 minutes. As an impartial observer, I obviously can't comment on any of the presentations. What I will say, as an outsider, is that it is very striking the extent to which the rule of law and the Constitution have been to the fore during the events of the last 18 months in Malawi. We followed them all closely at Africa Research Institute. We read the papers, we read research reports, and it is very striking the extent to which these two key issues featured prominently in the press, in the pronouncements of bodies like Public Affairs Committee and in public debate. So I hope that as a result you will find Dr. Janet Chikaya-Banda's publication timely, if nothing else. I also hope that you have found this event both interesting and informative, as I certainly have, and constructive. Just a last few words of thanks. I'd like to thank Hannah Gibson, my colleague, very much indeed. She worked throughout the publication process very closely with Janet, and she's here tonight, and I think she's done marvellously. I would also very much like to thank all those people who helped with the giving different views on certain of the issues that Janet raised. Honourable Benjamin Chikusa, Justice Ivy Kamanga, Dr. Edge Kanyongolo, just to mention a few. I'm sorry if I've forgotten anyone. It's unintentional. And your input was very much appreciated. I'd also like to reiterate my thanks to the three distinguished speakers. As I said, I think it has been a very, very interesting set of presentations and has left us all with a great deal to think about. Last and not least, I'd like to thank all of you, the distinguished guests, for giving your time this evening and for your attentiveness. And I would just like to say that the bar remains open and the food is still there. Thank you very much indeed.